This podcast is for informational and discussion purposes only and reflects personal experiences and opinions of our guests. It is not legal, medical, or mental health advice and does not create any professional relationship between you and I. Family court outcomes vary. Listeners should seek qualified professionals for guidance specific to their situation. This podcast may discuss sensitive topics, including emotional distress and family separation. Listener discretion is advised. Hey, dads, moms, supporters, family, and friends. It's Rachel Kay, host of the podcast Deadbeat Dad by Design. We are now on episode 16, which is crazy that we are already this far into the season. And I am really, really excited about tonight's episode because we have a brand new guest on. He is huge in the father's rights and the shared parenting, equal custody community. And so I can't wait for you guys to hear from him. And if you're watching on YouTube, getting to see who he is, the discussion is going to be great. And it's a very, very good episode. So make sure you stick around through my intro as always. If you are a mom, we know that you have gone through some of these things as well. And so we hear you, we support you, we love you. And this is a safe place for you as well. And we love you being a supporter of this show. So for today's episode, it is one that sounds really good on paper, but it falls apart really quickly in real life. This episode is called The Myth of the Best Interest Standard. And everybody's heard about it. You hear it everywhere when it comes to family court. The judges say it, the attorneys say it, the guardian ad litem say it, therapists reference it. It's supposed to be the gold standard, the guiding principle, the thing that protects children above all else. But here's the uncomfortable truth. What if the best interest of the child isn't actually a standard at all? What if it's just a phrase? A phrase that sounds objective, but is actually incredibly subjective. A phrase that gives the illusion of fairness while allowing wide open interpretation. A phrase that can mean completely different things depending on who is saying it. Because that's where we see every single day. One judge believes it's in the child's best interest to have equal access to both parents. Another judge believes it's the child's best interest to maintain stability, even if that means limiting one parent. One court prioritizes maximum contact, while another prioritizes minimum conflict, even if that conflict is one-sided or completely manufactured. So which one is actually the child's best interest? Because they can't all be right. And that's where the myth starts to crack. We are told that the system is built on consistency, that there are standards, guidelines, protections. But when the core principles itself is open to interpretation, what you really have is straight discretion. And discretion is where bias lives. It's where personal beliefs live. It's where experiences, assumptions, and even moods can quietly influence life-changing, life-altering decisions. And when you combine that with a system that has no jury, no requirement for proof beyond a reasonable doubt, no strict evidentiary threshold like criminal court, you end up with something that feels less like a standard and more like a moving target. Parents walk into court thinking, if I tell the truth, I'm going to be okay. If I show the facts, the judge will have to listen. But what they don't realize is truth is only one piece of the equation. Perception matters. Presentation matters. And most of all, behavior matters. Because in many cases, what gets labeled as the child's best interest ends up looking a lot like which parent appears more cooperative, which parent is more compliant, which parent is less reactive under pressure, which parent plays the game a whole heck of a lot better. not necessarily which parent is the right parent for the child to be with, not necessarily which parent is more honest, not even always which parent is more involved. And that's where people start to feel like they're losing their mind because they're watching decisions get made that don't line up with what they thought best interest actually meant. They're watching good parents get reduced, minimized, labeled, while the louder narrative, the more strategic narrative, starts to take center stage. And let's talk about that one for a second, because the best interest can also be influenced by something people don't want to admit exists in family court: narrative control. Who got their story in first? Who framed the situation? Who used all the right words and all the right language, even if they don't believe them themselves? High conflict, controlling, unstable, disengaged. One of those labels is going to get attached. And once it gets attached, it sticks. And now everything that parent does gets filtered through that lens. Even their love, even their effort, even their pain. So when a parent reacts emotionally to losing time with their child, it's not seen as heartbreak. It's seen as instability. And when they push back on something that's clearly unfair, it's not seen as advocacy. It's seen as conflict. When they try to expose the lies, it's not seen as truth. It's seen as escalation. And suddenly, the very things that make them human are used against them, all under the umbrella of the best interest for the child. Now, I want to be very clear about something. This is not saying that every judge is bad. This is not saying every attorney is corrupt and that every single case is wrong. There are absolutely people in the system who care deeply and try to do the right thing. But the structure itself, the lack of a true, consistent, measurable standard, creates an environment where outcomes can vary dramatically. And that's dangerous because children's lives are being shaped by this system. Relationships are being defined by this, and parents are being told to accept it because it's for the best. But here's the question that nobody wants to ask out loud. If two families walk into two very different courtrooms with the exact same story and the exact same facts and the exact same evidence, and one walks out one way and one walks out the other, they walk out with two completely different outcomes. Was it really about the child's best interest? Or was it about interpretation? And if it's about interpretation, then we don't have a standard. We don't have a standard at all. We have a system of opinions, and opinions should not be what determines a child's relationship with their parents. So what happens? Parents start adapting. They stop focusing on truth and they start focusing on strategy. They learn quickly. They don't react, don't show too much emotion, agree when they don't want to, and they stay quiet when something feels wrong. Because the goal shifts from being heard to being seen as compliant, because compliance is often rewarded. And that brings us right back to what we talked about last week. The system doesn't always reward the truth. It rewards behavior, it rewards presentation, and it rewards the parent who can survive the process, not necessarily the one who was right to be with the children from the beginning. And the hardest part of all of this is the children, because they don't get to choose how this plays out. They don't get to separate truth from narrative. They don't get to understand why one parent suddenly became less present and less important in their life. They feel it though. They feel the absence. They feel the tension. They feel the shift. And one day they start asking questions, questions that don't always have a very clean answer. So when we talk about the best interest of the child, We have to be honest about what really looks like this in practice. Is it truly about maximizing love, access, and connection? Or has it become a flexible phrase that justifies whatever outcome the system lands on that day in that courtroom with that judge? Because they are two very different things. If we don't start having this conversation, nothing will change. So maybe the real conversation isn't what's in the best interest for the child. Maybe it's why isn't there a consistent starting point that prioritizes both parents, unless there is a clear, proven reason not to? Why are we not starting at equal access and adjusting only when necessary? Why are families walking into court hoping for the right judge instead of trusting a reliable system? Why does something this important come down to the roll of the dice on who you get? Because that's not a standard. That is a gamble. And children deserve more than that. Parents deserve more than that. Families deserve more than that. So if this episode challenges you, if it makes you uncomfortable, if it makes you think, then good. That's the point of it. Because the more people that start questioning the language, the more people that start looking past the surface, the closer we get to real conversations about family court reform. And not just reform that sounds good, but reform that actually creates consistency, accountability, and fairness. Because at the end of the day, the best interest of the child should not be just a phrase. It should be something we can actually define, something we can actually measure, something families can actually trust. And right now, for a lot of people, it's not. I'll go ahead and introduce you real quick, Drew. To all my followers and listeners, thank you for staying through the intro. I always appreciate when you stay all the way through, and I always tell you that it's worth it. This week, it's super worth it. I got a new friend in the equal and family shared parenting community. His name is Drew. His camera's not working, so we don't get to see his wonderful face, but we get to see his screen and we get to hear his voice, and that's what matters. Drew is a huge advocate for the 50-50 and shared parenting community and knows the importance. He's also a father. He's, works in the legal field. He focuses really on the intersection of parental rights and the systemic integrity. And so, Drew, introduce yourself. If I didn't mention something, go ahead and say it for us, and then we'll kind of get into the episode. But and we'll recap a little bit about what we were talking about before I hit the record button. So,
okay. Let me see. Well, I'm a dad, and I like to read, and I like to apply what I read. And the legal system is like a big giant puzzle for me. I swear I'm
yeah,
a kid in a toy store, right? Like ever since I started doing this stuff. And I've just been having fun. Believe me, some of the listeners out there, I know how they feel because they had their kid like stripped for them, and it's like, whoa, I thought the judge was actually going to be fair, and then I paid all this
mm,
money, and I still lost big time. My kid lost big time, and I just left the courthouse with this terrible feeling, and my life sucks. But then I figured out how to fix it. I figured out
yeah,
how the legal system works, and I figured out some of the important things that 99.99% of pro se and maybe 75% of attorneys don't understand, which is the appeal, but I'll talk about that later. But
yeah.
that this has been a wild ride for me, but I also like to cut to the chase, so I want to get started on you. Enough about me. I'm ugly, by the way. You don't want to see my face.
No.
Let's get started with your episode so we can get these people some valuable information.
Yeah, I agree. I'm so excited that you're here. I know that you have such good advice for everybody. So the episode is all about, and I'm going to call it what it is, or how I see it, how I've heard about it, what a lot of other people see it as is the myth of the best interest of the children. And I believe wholeheartedly that the court system is using it as a slogan, but not actually as a standard. I think it's become this hot phrase, this slogan. They put it in all the documents. The attorneys are going to say it. The judges are going to say it. Guardian ad litems are going to say it. Therapists are going to say it. And you're going to hear it throughout your court case. It's what's in the best interest for the child. What's the best interest for the children? What's the standard of the best interest of the children? But there is no standard. And
Right.
that's kind of the truth behind it. There is no standard. There's no standard. We're going to start at 50-50. There's no standard. We're going to start with equal shared parenting. And so that's kind of what this episode is about, or that really is what this episode is about, is this myth that we all hear, that's called the, best interest of the children. And so my question would be, if it's the best interest of the child, why do outcomes vary so widely depending on who they get as a judge? Is that something that you have seen in your practice?
Okay, so this best interest thing, you've got to take a step back and think about, why isn't it the time of day that matters? Or
Mm,
why isn't it the gender of the parent that matters? Why is it called the best interest,
mm-hmm,
right? And the reason why that is because judges have to have some sort of final decision making in this controversy between two parents. And this controversy is a problem that exists first for the county in which you live in. Okay,
mm-hmm,
because that county has the judge that's going to decide your life at that point, right? So it's a
right.
county problem. A lot of people don't think about it that way. So the judge serves the county. The judge has to solve this problem somehow. They have to do something. So when they start looking into the situation, he said, she said, this happened, that happened. Okay, whatever happens, it's got to be in the best interest of the child. And the reason why this is important, and um I'm going to share something here. Let's see, so that everybody can see what it's a very important image. I would like to share
You're
it
good.
with you guys. So this is Caroline Norton. Okay. Now, 1800s, we're talking about the 1800s in England. Before Caroline Norton, the children and the wife were the property of the husband, because
Mm,
back then women and children were not educated. They didn't really do much in the
right.
cities in England. They were just property, a burden, uneducated, just like they didn't have rights. So Caroline Norton comes around and she's like, you know what? My husband is taking my kids and I don't like this. And at that point in history, there's a lot of women that are educated at that point. And they're
Mm-hmm.
like, no, we're not taking this no more. So they go to the British Parliament, and Caroline is hanging out with men in the parliament because the men are the legislators. So she's going over there. She's bugging the crap out of them. And eventually, the British legislature is like, all right, we need to we change our mind about things now, because now we think that the women should take care of the children and the men should go off to work. Okay. Now we're talking about the early 1800s. This is a war between Britain and France, and France and the world basically, but Britain and France, and Britain's trying to take over the world too, and they're fighting. And the one thing you need in a war is people. And
Mm-hmm.
there's another area called Prussia. The Germans came from them. They're basically Germans. But the Germans, they took it to a whole new level. But the best interest was came about because after Caroline Norton, the tender years doctrine is what she basically created. The mom is the best for the children. So they started taking the kids and giving them to the mom and making the fathers give them some sort of money to live off of.
Mm.
Um, and that makes its way down to the United States, makes its way out to India. It follows the British Empire because this is a British idea. So it eventually makes its way to the United States. Well, in the early 20th century, about 100 years ago, men started to complain. They're like, hey, you hold up. You can't just take my kids. So throughout the last century, the United States legislatures have been saying, hey, you know what? We need to do laws that say that the gender does not matter, and you cannot think about what's best for the father. You cannot think about what's best for the mother. You have to think about what's best for the child. And that's where the best interests of the child idea comes from. Okay, because
Mm.
they needed, like, the problem you have now where you're like the best interest is not of the child is not defined. Well, we're just coming out of an era where nobody even said that the best interest of the child was a factor. It was just the judges making stuff up. So we're actually, because it's hindsight now, we didn't see the past. We actually have it narrowed down to best interests of the child rather than best interests of the mother, which is what it used to
Right.
be thanks to Caroline Norton. So that's where you get your best interest standard from. Now, I agree with you and everybody else that best interest doesn't have any definition except for a few places. One of them is in Texas where they have the Hawley factors. And they say, okay, well, let's look at the Hawley factors. And some states actually have laws that list factors that the judge should consider, such as the caregiver, but they basically say the judge can consider any factor that seems relevant, and
That's what I was
that is
gonna
a
say.
problem,
Even in
right?
Tennessee, we have the list of,
Yeah.
I think it's like 18 or 19 things, or maybe 14. I'd have to go back and look, but we have the list. But at the end of the day, they also say, but the judge has the discretion.
Yes.
So they could throw this
Yes.
list out the door.
Yeah.
Before you go off that page, Drew, I want to read because this will also be on Spotify and Apple. So I just want to tell everybody what the screen says. It's a picture of Caroline Norton, and it says it's the ghost in the courtroom. And it says the origin, 19th century English family law reformer. And then the doctrine was birthed the unwritten rule granting automatic custody to mothers for young children. But the reality is officially it was banished in the United States by law, yet implicitly utilized by judges today as the default cultural operating system. So that's the screen that he's showing. Sorry, Drew. I just
No,
wanted
no
to make sure
worries.
they can know what we're
You're
looking at.
you're being proactive. You're making sure that the people that are just listening got it totally on board. And this
So
best
that's where that
interest,
standard came from, or what
yes,
they call a standard of the best interest.
yes, the best interest is definitely it's a benefit. We think it's a burden, but it was actually something to help, you know, parents because it was lawless before the best interest standard. And but there is no definitive definition of the best interest standard. It's just a do whatever's in the best interest and then be done with it. Because remember, the court system, it's kind of like a burden on the government, right? Because
Mm-hmm.
instead of people going around killing each other over disagreements, they can go to the court system. So instead of people running off with the kids or doing something, heinous, yeah, you go to the court. Court will solve your problem, and society, is a little better off, right, because of it. So the courts they have to be a factor. Output, 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 output. So this best interest is left undefined because they're like, let the judge figure it out. We don't care. The lawmakers really do not care. If they did, they would have
Mm-mm.
made it more strict. And let the judge figure it out, and let's go. get them out, get them out, get them out. But
Well,
then,
and
okay, go ahead, go
well,
ahead.
I was going to say one thing that you said that's perfect is yeah, it leaves a burden, but it's almost like creating a burden for a judge to pick between two people and have to say, well, this one's more fit than the other one. Instead of just being able to say they're both fit equally, it's like they've given the judge a burden to have to decide somebody's less fit than the other. Same reason why there has to be a primary residential parent. Even in 50-50 shared custody, they still pick a primary parent. And it's like giving a burden to a judge or whatever, a county, to sit there and go, well, yeah, this person's better than this one. This one's more fit than this one. When in reality, they can be, and there is a real possibility that they're both equally fit. They're both equally good, but one has to get labeled less than the other.
Okay, so we got back up from that one too. We got to zoom out,
You're
right?
going to
And
have
this
an
one,
answer for everything, I think.
I'll bet you I will. I bet you I will. The judge is not actually determining which one is better. Okay, they're not. And the Supreme Court in a few cases, but including in Troxel Granville, and Santosky Kramer, I believe there's a bunch of Supreme Court decisions that sometimes don't get read by judges now, okay? But there's decisions that say, look, and there's state statutes, by the way. Some states have statutes that clearly say, look, judges, you are to presume that both parents are fit. And the judges say, yeah, okay, that's fine. I'm giving the kids to the mom and the dad is paying child support. That's okay. And that's how it goes. Fine. Both of them are fit parents, but the judges always have they're predictable. Custody is going to the mom, or I want to say guardianship, because in the state statutes, guardianship can only be given to one person over a child or a ward, such as somebody who can't take care of themselves. So a child. And that guardian is the only person that has the final say. Now, when it comes to family court matters, the mother is awarded guardianship and the father is
Mhm.
awarded some rights afforded to all parents, making
Mhm.
decisions for the kids and stuff like that. But they're not a guardian. They look like a guardian sometimes, a pseudo guardian, if you will, but the mother is the guardian. She's the final say. So what the judge is actually doing is just picking guardianship. He doesn't care who's they're not picking who's better. They're not saying that.
Mm-mm.
Okay. That's
Yeah.
a myth. Okay.
Yeah.
But there's a
That's another myth.
reason why they're doing it that way.
It's I just the whole process is just
Mm.
it's unreal to me.
Mm-hmm.
The whole process of if there are two good parents, two present parents, two doing everything that they can financially, emotionally, spiritually, physically for those children, they can both walk into a courtroom and then one is going to be labeled the guardian and the other one is just a little extra helper. And
Yes.
it to me it's just ludicrous. It's ludicrous.
Yes.
Now, if there was actual proven abuse, actual proven neglect, actual proven, you know, disownership of a child, then we have another story. Then we have something to talk about. Then
Yeah.
then we bring in the experts, the police and the psychologists and anybody to help if there's abuse, DCS or CPS, whatever state you live in. But until those things are actually proven in a criminal court of law, not civil, then the standard should be 50-50. And that is what should be in the best interest of the children, not the parents. I feel like the court is rewarding the best interest of the parents.
And you're right about that. Okay, you're right that it's doing what's in the best interest of the mother for sure. Okay, because a lot of the courts they're still doing the tender years doctrine. It has not, even though it was abolished, it has not been put out of practice. So and the new lawyers that become judges, everybody knows or should know that are the only ones that can be judges in
Mm-hmm.
society. So those new lawyers, they just do whatever the previous judge did. They just go like that. Like they're not changing anything. They're just keeping the status quo. There's really no incentive for change when it comes to
Mm-mm.
the judges, you know. And when you talk about like the allegations, like they should, you know, if there's no proof on a danger to the safety and welfare of the child, um then there should be 50-50. Okay, now I agree. I agree that that should be one of the most important findings that a court makes. And findings are written down on paper, and they're the judge's like determination. They're from the judge. They basically tell you what they determined. So these findings should say, you know, hey, there was no danger, or yes, there was some danger, you know, there was some evidence that was brought in and I looked into it, and yeah, unfortunately I'm gonna have to like do something that's not
Mm-hmm.
50-50. But it's not like that, you know, they don't do it that way. And there is these allegations when they go into civil court, the judges who are presiding, even though you don't see it, they flip flop between a civil court judge and a criminal court judge, civil court judge, criminal court judge in the same hearing. They're a civil court judge because they're trying to figure out what to do with somebody's property and somebody's child. And then they're a criminal court judge because they're listening to somebody saying that this person who is a part of their family, who is a parent of the child, and who also possesses the property that this other parent is trying to take or wants the court to help them take, somehow did something bad to them that would constitute a crime. So the judge is flip flopping back and forth, right?
Mm,
So you've got some different things there, but what isn't happening that should be happening is that when the judges say, okay, there's this quasi criminal allegation and I have to make a finding on that, I should be using the criminal standards, such
right.
as reasonable doubt, clear and convincing,
Right.
but they're not. They're using preponderance of evidence.
Yep.
And that is something that people don't know and they don't challenge on appeal. That gets them every time. You know what I
Yep.
mean? So
That
yes,
is that's one of the things I hear the most of everything. I have people reach out to me all the time, and I'm sure you do too with your platforms. I have, you know, particularly mostly men, because
hmm
they're really the ones that are abused in the system more than women are, but sometimes women too. But I mostly have men that reach out to me, and that's what I hear the most. I hear the most is that they're being treated like they're in a criminal court hearing. There's no burden of proof. There's no without a reasonable doubt. There's no innocent until proven guilty. And this is supposed to be a civil matter, you know? And if you're going to talk about criminal things, just like you said, then we should be judging them on a criminal level, which requires there to be a burden of proof. It requires reasonable doubt. It requires all these other things, and they're not doing those things. And so men are being falsely accused, and their children being taken away from them, and then
that's
their
right.
relationships destroyed.
Yep.
Destroyed.
Yep.
Oh, I like this screen that you're pulling up.
Okay, so this one, a lot of people think that the court system is, like the screen says, an arena of moral judgment.
No,
Okay, and it's not.
it is
It's
not.
an economic system. One of the things that I really hate is attorneys who pull all sorts of tricks just to win the case, and
Mm.
they ruin someone's reputation by making false allegations and stuff like that. And they know they don't have any evidence. They know they don't have any
Oh,
evidence,
yeah.
but they say things that are prejudicial in court. They go in there and the judges ready. He's like, all right, I got a dude, I got a lady. I'm going to give the kid to the lady. I'm going to make the dude give the lady money. There it is. But
Mm.
then, so that's the judge's predetermined condition, his initial condition that's what he wakes up in. But then an
Yeah.
attorney comes in and says, "Hey, judge, this guy over here, he's a criminal. He's abusive, and he does all these terrible things. And I forgot to bring any evidence or whatever, but it's all true." And the judge is like, "Okay, well, you're an attorney. You probably wouldn't say anything if it wasn't true, so it must be true." And then the dad's over there, and if he's by himself, he's like, that's not true, or like, can I say something? And the judge is like, no, just hold
No.
on. And he's like, but your honor, they're saying things. And the dad's frustration comes out as confirmation of what the
Now he's
attorney just
hostile.
said. Yes, right. And he's just trying to defend himself, and he doesn't know the rules that the attorney gets to keep talking. The dad will have a chance, but he just has to be patient and pretend like it didn't bother him, which 100%
Mm.
of dads can't do. So the attorney says something, and the judge is like, okay. But then if the dad does have an attorney, the attorney doesn't say anything, and the dad is looking at it as an attorney like, what the fuck, man? So the judge is paying
Mhm.
attention. And I'm sorry if I cuss. You can bleed. I'll try
You're
to limit
you're
it,
okay.
but okay.
You're fine. You're fine.
All right. So the attorney goes and doesn't even address it. The attorney just ignores it because they had a plan to do something else. And
Mm.
there's no way you can disprove that right there at that time. You have to go get witnesses. You have to put the mom on the stand and be like, tell us all this stuff, but that might be scary. There might be something that your client did not tell you before, you came in here. You might end up finding out that your client is some sort of criminal. So you never know. So the attorneys are just like, we'll deal with this later. So they don't do anything.
Mm.
So the judge is left, and he's like, well, all right. Well, I'm going to do a temporary order, and you're going to pay child support, and you're not going to be able to see the kids unless you go to some sort of supervised visitation. And then we'll figure
Ugh.
this out later.
Yeah.
And that's what happens in
Mm.
those situations. And it's all because some attorney said some prejudicial statements without having any evidence. And at that time, it's like, whoa, hold up. Like, this is a real hard thing to do, because sometimes those situations are true.
Yeah.
Sometimes it's like one of the parents is violent, and the judge is just like, look, I got to do what's in the best interest of the child here. So you're not going to be able to see the kids, supervised visitation, but you do have to pay child support. We'll figure this out
Yeah.
in 45 days.
Right. I
you
did a
know,
whole entire episode on this.
nice.
You'll have to go back and listen to it. It's all
Okay.
about, I called it safety words. Um, it's an entire episode on safety words and how they're used as weapons in court. And a lot of times, family court pays out more than criminal court does. If people don't know that, like family court attorneys make a lot more money than criminal court attorneys. And so you have a lot of criminal court attorneys that moved from criminal law to family law, but they treat their clients and other clients as they would people in criminal law. And so they know the hot button words to throw out. They know the safety words to throw out to stop everything, to get the judge's attention, even if it's not true. And it's
Hmm.
completely unethical. But there are hundreds, probably thousands of attorneys out there that will do it. And all it takes is one allegation of abuse, one allegation of severe neglect, one allegation of whatever it is. And just like you said, the judge will be like, oh, whoa, 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 whoa. We got to stop this. No contact. Or maybe supervised visitations. Now we have to set a different trial because we have to go all over, there's got to be evidence and everything else. And what the dad, let's use the dad, for instance, going into this doesn't realize that like he just got screwed, and it
Hmm.
could be months, it could even be years before this goes to trial or finishes, that he's going to lose that relationship with the kid. And the other attorney knew it the whole time, and that was their plan, and that was all they needed to do was throw out a safety word, throw out a something to keep the father away from the kids and play the long game. All the while they're collecting more money from their client. And it is, I had an attorney actually come on the show once that admitted it. He was like, I've done it. I've known what to say. And he said, I don't practice that way anymore, obviously. And a lot of things have changed in his life now, but like, that's what they do. And it is so not moral at
Oh.
all, completely unethical, but it happens. And it happens every day in family court. And I get it because then the judge, they do, like you said, like there really could be abuse happening. There really could be harmful things going on, and the child might really need to be taken out of that situation. But there also really couldn't be. And you've just destroyed an entire family and gambled on that fact. And then the saddest part of it is a year or 2 years later, when we find out that they were false allegations, they were lies, mom doesn't get in trouble. There's no repercussions. There's no, there's, I used to say there was a slap on the wrist, but I don't even think there's a slap on the wrist. It's like oh, okay, they did it. Oh, it wasn't true. Sorry, dad. Sorry, we took 2 years of your life. You have to be reintroduced to your child now. So it's going to be a while before you get to actually have the custody that you deserve in the first place. It's a messed up system. It's just, there's no other way to say it. It's just so messed up.
That's humans. Humans they mess things up. And the thing is though, well, I enjoy one of my biggest thrills is prosecuting other attorneys based off of what they're doing. And I will report them to the bar and we will sue them for malpractice.
Yeah.
We will try to get them disbarred so that they never become an attorney again. And that's the thing, is they don't know that people like me are out there. So they end up messing up, and sometimes they just get a slap on the wrist or something like that, but we can kind of fix what they did, but it does take a little bit of time and some money. But there are actually small pockets of attorneys that are saying, no, we're not going to let this happen. You can't go in there doing that stuff. And the reason why the moms don't get in trouble is because it wasn't the mom who made the statement. It was the attorney. And the correct thing to do is to get an objection on the record that basically says, the attorney's testifying and he's making prejudicial statements, and we got to strike that from the record. And the judge should tell the attorney to please stop making those statements unless they have proof. That would be the correct way to do something like that. And then if necessary, you just do a mistrial. Be like, you know what? Sorry, we need a mistrial because the attorney messed it all up, man.
Yeah. The other thing I've seen is like attorneys, if there's multiple kids involved in a case, and one is close to aging out, the other stories we've heard and seen are like an attorney will keep pushing final trial, getting it pushed past that child aging out. So now they're over 18. Now they don't count. They've already been so far alienated and they're gone. They're completely gone. That's the other one that just makes me sick. And I've heard so many stories like that, mom alienated the kids away from dad, and the oldest one was the target of most of the alienation, who then helped alienate the littles, because they were so alienated. They helped their younger siblings be alienated. And then by the time final trial rolls around, they've aged out and they're already gone. And so now, they're out of the equation completely. Dad can't even fight for the oldest anymore. So now dad's left to fight for the younger one or the youngers.
I want to show you another one here.
I got to tell you, I love your slides. This is a first for my my show so far. So this is a new thing, and I'm loving it. I wish all of my Apple and Spotify listeners, if you're not usually on YouTube for this episode 16, you need to pop on YouTube so you can see Drew's screen here.
Oh yeah, those views are gonna take off now. Yeah, if you're not watching the YouTube video, Oh, you're missing out because this is me. I do a lot of visuals. I know.
I love it.
I'm just that guy. But this image right here that I'm showing right now, and
I
one of
love
the
that.
things that I stress people to do just naturally, just as a human being, just do it, is to have empathy, which means to put yourself in other people's shoes. And I would like for everybody to just put yourself in the judge's shoes for a minute.
Hmm.
Judges are either elected or they're appointed, which means that they know somebody, right? They know
Right.
somebody. They're working their butt off to become a judge. That takes money. You have to be a lawyer for a certain amount of time. You gotta have a bachelor's, plus you gotta go to law school and you gotta pass some exams.
Hmm.
And then you gotta be a lawyer for a little while. And then you gotta try to get elected, or you gotta try to get the governor to appoint you. So being a judge is like difficult work. And it's akin to running a business, to being an entrepreneur. And a lot of people are not entrepreneurs. They're not career people. They're just workers, so they don't see that perspective. But it's necessary to see the judge as a career person. And if you know about career people, they don't spend time with their children. They
Mm,
love them, but they have a wife or a spouse or a mom or somebody taking care of the child while this person is taking care of their career.
mm,
So when they see a dad come in and the dad's like, I want my kids, that looks weird. Because, like, no, you should want to go get money and you should want to have a title, you know, uh, Your Honor. Mine is Your Honor. Why don't you have a title? Like, what do you want to spend time with your kids for? Just give the kids to the mom, let her handle them, and then give her some money. And it's not that much money. It's only like 16% of your paycheck. And go to work, go hang out with your friends on the weekend. That's what I do. I skip out of the house. I can't be around them kids. They're loud. That's the judge mentality, and people don't
right.
understand that. And it's necessary to go in there when you go, and your lawyer or yourself, if you're pro se, should go on the stand and tell the judge, hey, look, man, I don't know how I know you work a lot and you don't get to see your kids, but I would rather sacrifice money to spend time with my kids. And that's what this slide says. That's what this image
Yeah.
is. It tells you, judges are they get off of work, they got to worry about being stabbed, shot, run over.
Hmm.
Like, people
Hmm.
don't like them. And then they got to go home, and they don't want to spend time with the kids. They got case stuff they got to do, so that's their perspective. That's what it looks like in their shoes. So it's necessary for people to understand that and have sympathy or empathy for the judge, because you won't get anything otherwise. You can't
Right.
hate the judge and expect them to do something for you. You have to have that empathy. But the truth, though, is that the judges have a predetermined outcome.
Yeah.
Just take a case where there's no allegations. Both parents are fit parents, right? And the judge is going to do the same thing in that case, no matter what,
Hmm.
right?
Right.
And what is your experience? What do you like, confirm for me what you think the judge is going to do?
Yeah. I mean, I think in most situations, the judge, whether there's allegations or not, they're already, like you said, predetermined, especially if you're in states that are not shared, right? That don't have the laws passed for 50-50 as standard. And they're just gonna sit there with their thousands of caseloads, not think about it, and it's gonna be mom gets 70%, dad's going to get 30%. Dad's going to get every other weekend, one day during the week. He's going to pay this much child support based on his income. Everyone's going to be happy. You're going to walk out and everyone's just going to listen to what I say because I'm the judge and the jury when it comes to family court.
Mm-hmm.
Right.
Okay. All
And then
right.
you're going to have a dad that's sitting there going, wait a minute, like, I'm a really good father. I have no criminal history. I don't have drug issues. I have a roof over my head. I have a car. I have a career. I deserve to have my children 50-50. What do you mean I only get them every other weekend when I helped raise them from the moment of conception or moment of birth? I was there. I was doing the diapers. I was doing the feedings. I was doing the wake ups and the baths and the changings. I was helping with discipline, helping with homework. And mom decides she doesn't like me anymore and she leaves. And now I lose my kids over it. That's what I see the most. That's what
Yep.
I see happens the most. And I will say, I do agree with you that we need to have empathy for these judges. Like you said, we don't know what they're going through. And I am sure they have death threats. I'm sure they have people that hate them. Um, they don't have time for family life. They do see thousands of cases a year. They have stories running through their mind. They're constantly wondering, did I make the right decision? Did I make the wrong decision? And am I sending kid to an abusive family? Am I sending them to the right place? I do think that we do need to have some empathy, but I do think that judges should also have empathy for fathers. And I don't see that in
Yeah.
all of the research I've done, all of the stories I've heard, the hundreds of groups that I'm in, personal things that I've seen. I don't think these judges have empathy for fathers or mothers that are fighting for their children. And so I do think it should go both ways. I think if we're going to have empathy for the judge, then the judge needs to have empathy for the clients as well. And I don't think they do. I think they're jaded. I think they're stuck in a system where this is how it's always been. This is the best interest of the children is what it's always been. Mom gets primary custody. Dad gets every other weekend. If he's lucky, he might get an extra day during the week. He might get a couple weeks over the summer. We'll throw him some holidays to throw him a bone. There, bada bing, it's done. Nobody fight me. And if you do fight them, if you go back, well, now the judge doesn't like you because you've just questioned their godly authority. They are all knowing, all ruling, and you're questioning what they asked or what they decided. And so now judge really doesn't like you. And I don't know how it is in other states and other counties. I know in Tennessee, your judge that you have for family court is your judge till the end. You don't have different judges. So every time you have to go back, anytime your co-parent drags you into court for whatever it is, you're always going to have the same judge. So if they don't like you once, they're not going to like you for the end.
Okay. That there's a way out of that. There's a way out of that. And I can talk about that later. When hopefully we can discuss some of the actual like legal strategies that parents should be employing. But for right now, there is a way to actually change judges. It's a due process right, so that if you know your judge has an interest, you can get rid of them. But yeah, but then there's pros to that because the judge knows the case. You know what I
Right.
mean? If they're a good judge.
Right.
But yeah, now there the one thing that I think people keep missing is this right here.
Oh, I like
And
that one.
okay, now it's not even the best interest of the child. I'm going to be honest with you. We've come a long way and got to the best interest of the child, but it's not even the best interest of the child. It's the best interest of the state.
Mm,
Okay.
there it is.
Now, originally, child support, and the reason why I'm going with child support is because it has such a control over our country now. Now, a lot of people don't know this, but the Germans, these Prussians I mentioned earlier, these old school Germans, during this Napoleonic War and all this stuff going on, they figured out, hey, we need more people. How do we get more people? We need women to have more babies. How do we get women to have more babies? Well, we got to have them, they got to do the deed and they got to get pregnant. How do we get them to do that? Because pregnancy is painful. Give them money. So the Prussians, under Otto von Bismarck, implement this social welfare reform. Now they entered workers' rights. They entered like so many things to draw people to Prussia to create a war making economy. And they did so many things other than child support, right? They had workers' rights, they had injury right, like compensation, Social Security, a basic form of Social Security and stuff like that. So people were flooded to Prussia. They were coming in there, and Prussia had a good thing. Well, of course, this notion of child support made its way into Germany when it was founded. And during the 1930s, President Roosevelt, he had visited the Germans, he knew about the Germans and stuff like that, and what was going on over there in Nazi Germany and stuff like that. Where everybody knows that the Americans brought rocket technology and weapons technology from Germany, but we also stole socioeconomic technology, and we stole their Social Security system, and we stole
Mhm.
their child support system, and we stole some other systems. Well, once we brought over the child support system, computers didn't exist, so it was kind of hard to track people. People were abandoning their children, and the government was paying for these children. Damn, we got to take care of all these kids. Well, computers come around and social security numbers, and they can start tracking. And in the 90s, they were like, all right, we're good. We can start. We got the parent locator service. So when people get hired, we get notified, and then we tell the employer start garnishing wages. So we can start taking people's money, and they can't do anything about it. So we're just stealing people's money. So it turned out to be a great thing. And Bill Clinton was a part of it. And the child support became incentivized in
Mhm.
1996. So the number of child support orders directly correlates with the amount of money that a state can receive. Now, see, there's this big pool of money, tens of thousands of dollars or hundreds of thousands of dollars. I'm sorry, hundreds of millions. Okay,
I
hundreds
was
of
gonna say, I
millions of
think it's in the
dollars.
millions.
Okay.
Yeah.
Now, this pot of money, all the states have to fight for it. Okay, they got to fight for it. So they have to meet these certain criteria, but issuing child support orders is basically the most important one. If you don't issue a child support order, you're not going to meet all the other criteria. You've got to outcompete the other states. And that is why when we look at Texas and California, California has twice the amount, twice the population. New York has about maybe it doesn't have twice the amount. It's like maybe 1.7 times the amount of Texas. And you would think that if you have the higher population, you probably have the higher number of divorces and the higher
Mhm.
family cases. So therefore, you have the higher amount of child support orders. But when we look at the data, we see that California doesn't get the most in incentives. It's Texas. Somehow, a state that has half the amount as California is making twice the amount of incentives. Okay. And we can clearly see that Texas under Greg Abbott was actually in the Supreme Court during the time that the child support was being incentivized in the 90s in the Texas Supreme Court. And then he became the Texas, what they call the Attorney General, but he was called the child support czar, right? And he turned that system into a money-making machine. And other states haven't really caught on, but they still do it.
Right.
And this money, it once a child support order is issued, the judge has to sign a piece of paper and tell them some certain things, such as is it the mom, the dad, the uncle, the grandma, who gets custody, who pays child support. There's these certain titles that have to go down there. And then they put how much, and they put the obligor's social security number, and they send that off to the child support enforcement agency. And then they send that off to the federal government every quarter, and they're like, here, this is how many child support orders, so you should be giving us, this is for the money. You said you wanted this information in exchange for money, so we got it for you.
Mm.
And the money comes down, and it goes to the state child support enforcement agency. right? And that could be
Mhm.
run by a attorneys general, or they might have a separate agency depending on the state. Each state is different, but that money goes to the child support enforcement agency. Well, this state agency then enters into contracts with the counties, and those contracts can be tens of millions of dollars. Okay.
Mm-mm.
The counties then take that money and they get to use it as pocket change. So one of the things that they do is they say, "Hey, judge, I know you have a state salary, but we want to give you a salary too, because we have some extra money. We're going to give it to you." And the judge is like, "Yeah, sure." And the state side and the county is like, "Man, you're doing great. The child support stuff is doing great. We're making a lot of money." So the judge is a smart person. They know. So they keep issuing child support orders because they know that it generates money that comes down to the judge. If the judge stopped issuing child support orders, the county would be like, "Bro, we don't have any money to give you." Okay.
I've heard this, but I've never heard it explained so wonderfully like you just
Oh, well,
explained
thank you.
it.
I'm
Well,
taking
you
a
gave the
bow.
history behind it too of why. I've heard people say this, and I'm like, this doesn't make any sense, but I get it now.
Oh, yeah.
It makes
Yeah,
sense.
and one
Perfect
of the
sense.
craziest things that we figured out, and I'm gonna throw a name out there. My buddy Terran Champagne is the guy who really got this information and made it so that I could compute it and explain it to others. But one of the craziest things we found out was, when you get hired, there's a parent locator service. They run your social to see if you have a child support obligation. Well, the little tiny state of Rhode Island, their government runs that operation. They have the computers, they do all this stuff. And all the child support agencies from all the states, they have a contract with the state of Rhode Island to operate the parent locator service. So there's another flow of income that goes to Rhode Island. So
Wow.
if any foreign nationals are listening, please go after Rhode Island first. Like leave the rest of us alone. Rhode Island's a bunch of traitors, you know.
I didn't even know there was such a service. So when you get
Yes.
hired for a job, that's part of your background check is to see if you have to pay child support legally.
Not your background check, but it's part of the tax process. Whenever they process your taxes and your income, they send off your tax information to the Social Security Administration, IRS, and
Right.
the Parent Locator Service.
I knew the Social Security or the IRS, but that's
hmm
insane.
It is. And these child support agencies, they know who your phone provider is. They know where you live. They know what utilities you pay, because every time you put your social down on something that gets like processed somewhere, the child support agencies were granted so much authority that they
Oh.
resemble an intelligence agency such as the NSA or the CIA. Like the child support agencies can do basically the same thing that the NSA can do.
Oh my gosh.
Yeah,
That's
it's crazy.
insane.
It is insane and scary at the same time, you know what I'm saying? But it's this money. It's this economy of money that goes all the way back to Germany because they want to create more people. But
Mm.
and this is the big but that I hope brings joy to a lot of people. Let me go back over to this other screen here.
I'm glad I wore my glasses today. I don't usually wear my glasses on the show, but I can actually see.
This is the fun part. This is
Okay.
the fun part for me. Okay, this is where this is where we get to make judges and lawyers scared. Okay, this is the part of the podcast where we get to get a little bit happy. Okay,
Okay.
those incentives that I talked about, they're identified in chapter 42 of the laws of the United States. We call those the United States Code, or USC.
Okay.
USC. So United States Code. So in chapter 42 is where we're going to find stuff related to Social Security and welfare benefits. Now, It's a big chapter with a bunch of subsections. One of those subsections has to do with welfare, and it has to do with needy families.
Mm,
So the federal government was like, look, we're going to give out money to for this child support stuff because we got all these abandoned kids. This is a big thing. These abandoned kids, and abandoned kids have been a burden on society for years. Even in England, William Blackstone, 1868, he writes a book, and in there he's like, look, we're gonna have to violate people's property rights. We're gonna have to take their property if they've willfully abandoned or neglected their children. And that should be the only doorway to use child support, in my opinion. But
right,
all the way back to England, 1868, William Blackstone. So the federal government is aware of this. That's the big problem, is the abandoned children, right?
right,
We've got these abandoned children. We need to go after that. So the federal government's like, look, we're going to incentivize you because we're giving out welfare. We don't want to do that anymore. We're just going to take it from the dads. We're going to incentivize the states. So under 42 USC 658A, that's where the incentives live. That's where it tells the states, this is how you compete. This is how much money is going to be in there. This is how you win the game. Okay. But before you get to section 658A is section 601, 42 USC 601. Now, this is the framework for everything related to child support. Okay, if
hmm
it's not, it identifies boundaries, some very excellent boundaries, in my opinion. Now, further in Chapter 42, we find the laws that allow states to use someone's social security number for child support. Otherwise, that's identity theft.
right,
Okay. But for child support purposes, we're going to allow a state judge to use a person's social security number. And they do that in numerous laws that come after section 658A. But 601 still says, hold on, here's boundaries. We have a playing field. It's not an infinite field here.
right,
Two of the most important things in section 601 is that, and it doesn't say this explicitly, but you have to understand that 601 governs the use of the social security number for purposes of child support. It says that anything that happens with the social security number and the child support, right? Not explicitly, but anything that you use these laws to do must be used to do a couple of things, and two of them are important. The first one is that it has to discourage the occurrence of out of wedlock pregnancies. We don't want single parent families. We don't want baby mamas by themselves. We want people to have children while they're married. Okay. Otherwise, you can't use that social. Another criteria is that it has to have a preemptive effect. Child support is to encourage the formation and maintenance of two-parent families. Okay, because they want people to stay together, raise the children.
right.
We don't want children to be soldiers. We want quality children to be soldiers, right? We need quality. We don't want trash. So in order to use the incentives, in order to use the social security number, you can't do the opposite of these things. And if you go look at the judges and you look at them giving out child support to mothers, what are they doing? They're actually incentivizing mothers
Right,
to have multiple children with multiple fathers and to
right.
avoid having a two-parent family.
That's what I was
So
gonna say. They're incentivizing it.
there you go. They're doing it themselves. Now, this is a big thing, because defrauding the federal government is a big no-no, and that's under 18 U.S. Code 666, which I thought was weird, but or suspicious that it would be the sign of the devil, but it's actually like judges can spend up to 10 years in jail for defrauding the federal government. So if they're implementing a system where both parents are fit, yet they're making one of the parents pay child support, and then they're kind of disintegrating the two-parent family. So now this child does not have the benefit of having a two-parent family.
Mm,
And then they're telling the federal government, hey, give me some money because I fixed this problem. And they give the money. Now that's fraud.
right.
Now it's fraud. And this is where judges get scared. They don't like this. They do not like getting hit. Now there's a lawsuit, a whistleblower lawsuit that anybody can do on the planet. Anybody can do is they can step in as a plaintiff on behalf of the United States government and say, we need to file a lawsuit against this company or this person because they are defrauding the United States government. The United States government's big. They're worried about global economies and war and stuff like that. They're too busy to look down here and see that they're being robbed. And this comes from the Civil War. Military contractors were given all kinds of crap equipment, defrauding the federal government. So these laws came out in the Civil War. But we can use them now. And what we do is we file what's called a qui tam, Quitam. And that's a special kind of lawsuit where anybody can be a quasi prosecutor. So what we do is we sue judges
Mm,
and we say, hey, guess what? We're going to sue you. Department of Justice comes in, and sometimes these things just filter away, because the judges are like, all right, fine, whatever, or they recuse themselves and we get another judge and then we got to start off with somebody else. But it's a lengthy process. The qui tam is actually a lengthy process, but it has an effect on judges because they don't really have any skin in the game. They're dividing up
uh-uh.
families. They don't really care. But when they get a lawsuit that says that they might have been defrauding the federal government, well, now they got some big skin in the game. You know what I'm
Now
saying?
they're
We're not
scared.
talking. Yeah, now they're scared. Yes. So, but this incentive system is why it looks so awkward. Why are good parents not getting equal custody? Why are children not having equal access? It's because of the incentive system.
Right. They don't make any money if
Yeah,
there's shared parenting and there's no child support, then the government doesn't make any money.
precisely.
Yeah.
Yep.
And I know, so you have a guide that you're creating, correct? For
Yes.
parents that are going through this currently, that are going through high conflict custody battles or just custody battles in general, to help them navigate the gap between judicial discretion and the actual law, correct? And is some of this part of that guide?
Yes.
Yay.
This stuff is all part of the guide. It goes out and it's not finished yet, but we're making one for Texas and Virginia and California.
That is
Um,
amazing.
so people in those states will be able to, purchase a guide and use it for themselves. And, there's it's still a big challenge for people because not having a background in law and or even practicing the law and a
Right.
practical experience to see that it's not, the rules are different than what they say they are. But it will get people to have some sort of leverage when they go into a courtroom, and it'll help them prepare for appeal, because the
Yeah.
appeal is the most important thing. I want to say 90% of attorneys don't even care about the appeal. They're just like, I'm going to just go and make my paycheck and make it look like I'm doing something.
Right.
And then I'm going to take my money and go home and do the same thing tomorrow,
Yep.
so they don't care about appeals. But if you're
Do you think
going to
that's
go to
because
court, go ahead. I'm sorry.
I was going to say, do you think that's because so many people don't appeal? Because they're discouraged to appeal?
They don't even know what it is. And here's the thing.
Yeah.
You can't appeal unless you knew you were going to have to appeal and you prepared for the appeal before you even went to trial.
Right.
So if you're not doing it from the very beginning, like before you go to the judge in the courtroom, you better know what you need how to win on appeal before you even go to the trial.
Mm.
And people don't even know that. Lawyers are just like, screw that. You know what I mean? Like, I don't want to be an
Yeah,
appellate
I think they
attorney.
discourage it.
Yeah. So
Yeah.
it's naivete, but yes.
Will
But
this guide kind of help people that want to try and do pro se?
that's who it's for. This guide
Okay.
is going to be for pro se people. We have another guide that is for lawyers, because they need. The great thing about pro se people is that they've got nothing to lose.
Yeah.
They've already lost it. They've already lost their kids. They're losing their money. They've lost some of their sanity. They got nothing to lose. So they're like, okay, you know, I'm done with the lawyers, and I got ripped off by some guy telling me I had to challenge jurisdiction or something, but I need something else. And when they see this stuff, like they'll see, okay, this is comprehensive. It actually makes sense. Like I'm learning as I'm going along, and they'll do it. You know, they'll do it. But attorneys are like, wait, I don't want to get blacklisted. I want to make the judge mad. It's like, yeah, no, but you're gonna be helping your clients. You're gonna be changing the world. Because
Mm-hmm.
these children that are in America today, these fatherless children, they're a danger to our national security.
Yeah.
Okay, a big danger to our national security, an unacknowledged danger to our national security. So it's a monumental effort. So they kind of owe it to future generations to change the way the system is, but they're only thinking about now. They don't want to get blacklisted, and they want to keep working as an attorney, and they don't want to be called out for making arguments that challenge the system and have valuable evidence to do
Yeah.
so, you know? So, yeah.
Yeah. Well, I think it's incredible. I think it's going to be such a good tool for people in those states. And then hopefully eventually you'll just, do your life's work and do it for all the states. So,
Yeah,
but I know it takes
that's
a
the
lot of
goal.
research and a lot of effort. But yeah, there's a just I, I'm excited to be a part of our community. I see that it's growing and it's evolving, and there are people fighting for equal share parenting, for um, removing child support when it's unnecessary, and fighting against the system. And there's people that are not afraid to speak up anymore. And I think it's incredible that there's such a large community of people that are doing this. And we talk about it a lot, that it's mostly men that are abused in this system, but there are women abused in the
Yeah.
system as well. But I'm glad that there's more women like myself that are starting to join forces and speak up and say, no, this isn't right, Um, and so I think it's incredible what you're doing. What is this? Tell me about this page real quick.
Okay. This is some of the things that some words, some phrases that regular people don't know about, right?
Yeah.
And in the red letters, right? There's this veil of there's this belief that that there's emotional fairness and best interests of the child. Some judges and lawyers will say that the child support is for the standard of living for the child, but the child support actually belongs to the person receiving it. It's not even for the child. It's a compensation thing.
Right.
And some parents believe in telling their story, like, Your Honor, I gotta tell my story. And then when things go south, they ask for a do-over. And that's not gonna happen. That's just
Mm-mm.
not gonna happen. But the way in which we do things, right, is we say, hey, wait a minute. There's this philosophy out there called strict scrutiny. And it basically says that there's certain types of issues in society, such as parental rights, the right to life, liberty, stuff like that.
Right.
And if the state is going to write a law that allows a judge a state judge to interfere with these fundamental rights, whether or not they're written down in the Constitution or not, we can imply that they exist without them being written down. But if a judge is going to interfere with these rights, there needs to be a compelling state interest, like a compelling one, such as abandoned children, right? Abandoned
Right.
children, that's a compelling interest. We'll take your money.
Right.
Yes, do it, do it. Okay. But if a parent has not willfully abandoned and neglected their children, well, there's no compelling state interest here. This is not an abandoned or neglected child. This is a regular child that's being taken care of. So that law cannot be used in these instances, at least for child support. And the law, when it is implied or when it is used, it must be like the lightest touch. Like taking someone's money. That might actually be too rough. We need to like, hey, how about some counseling or something to get you back? How about we get you a job? How about we do something like that rather than just, we're going to take your money whenever you get some.
And
So it
then if
has
you
to,
don't pay it, we're going to throw you in jail. So you're
yeah,
going to be further behind. And then it's going to be this
exactly.
vicious cycle. Yeah. How
Exactly.
about some financial counseling? That's a good
Eh,
idea.
There you go. Least, and that's called the least restrictive means. It has to be a light touch. And then if it doesn't work, sure, hey, we're going to put you in jail because you abandoned your kids and you're not taking care of them, or we're going to take your money or property or something, but we're going to do something, but not right away. They can't just go and the right to property to be free from unlawful seizure, that's what we're talking about here. And they're just violating it just because you showed up and your gender is what your gender is. You know,
Mm,
if you're a male, well, all right, you abandoned, we got to put you on child support, which is also a lie. Not
mm,
in any one of the 50 states is there a law that says that the dad must pay child support or that the judge must make the dad pay child support. N- Nowhere in any state law does it say that, but the judges and attorneys will tell you otherwise. But
mm-hmm.
there is no law. um, the other thing is the fiduciary conflict, the judges having an interest in the child support money. That's one thing, and you have to make that claim, and you have to say, hey, look, judge, we're going to actually ask that you split the case in the custody and child support. And custody, we're willing to talk about custody, but child support, you can't talk about child support because you get an incentive. So hold off on that. If you try to talk about it, I'm going to ask that you're recused or
Mm,
disqualified, and another judge is gonna come. But guess what? That judge has the same thing. So this is gonna go on forever. But let's just talk about custody because we can get that one out the way. So it makes judges focus on custody first and makes them hate talking about child support, right? So we want
that's
judges to
smart.
hate talking about child support. The other thing is the appellate record, preserving factual and legal sufficiency. Like abandoning your child. Okay, that's a that's a legit reason to come to court, right? But telling your child that you don't like their shorts, that's not. Okay. You can't bring that. Like nobody can say, "Hey, I'm going to take this guy to court because he threw some dirt at my kid." Was it radioactive dirt? Did it have like needles in it or something? It was just regular dirt? Okay, no, sorry. Like you can't, sorry, bro. But okay, abandoning or neglecting your child. That's legally, I mean, that's factually sufficient. Okay, fine. Fine. We can go with that. The judges will entertain that controversy. But when you go through the hearing and they just say, well, so he abandons the child half of the week with me and then he comes back for the other half and then we kind of keep doing that. So he's abandoning the kid. And it's like, yeah, but you're the mom and you guys are sharing, right? Well, yeah, but he's abandoning the kid with me. It's like, okay, that's not abandonment. You guys are actually
That's not
sharing.
abandonment. He's not leaving the kid behind a dumpster with no food, no water. He's giving him to the mother to take care. Yeah.
Exactly. And that is where you get to the legal sufficiency, where it's like when you go to the appellate court is going to be like, okay, you want to appeal. Is this a case? This is a case about someone throwing harmless sand at your kids? Oh, yeah, we'll appeal this. What? You shouldn't have done this. The judge should have thrown. Why did the judge take this case? No, this is gone. This is not factually sufficient.
Right.
But then they say, oh, okay, it's an abandonment. It's a child support. So there must have been an abandonment case. Okay, let's look at it. Okay, but then we look at the record and the mom specifically said they're sharing and the dad's there and there's no abandonment or neglect. This has got to be appealed because there's no
Right.
abandonment or neglect. So we can appeal this and take off the child support because it's not necessary. So that's kind of the things that you really have to look forward to in an appeal, especially, and the ultimate thing that we try to do always is that you want to make sure that the court record has enough evidence in there to show that the judge could have only made one decision, and it's not the one that they made, but they only could have made one decision, and that's the one that you asked them to make. And that's
Right.
the hard part. That is the, like, it's nearly impossible to get 100% that way, but that's the ultimate goal that really people are not factoring in. They're trying to, like, persuade the judge through emotional appeal or something like that. But in reality, it's about proving that there's no abandonment or neglect. And
Yeah.
that's the ultimate goal. But yeah.
This is going to be so helpful for people. It's going to be a game changer, I think, for people, especially people that are doing this pro se. Um, changing their verbiage and what's really legal and what's not, and understanding how the system actually works and how it's supposed to work. Um, so I'm excited. I can't wait till it comes out. I don't live in any of those states, but I might get one anyways, just so I can, see what everything is, and maybe I have friends that, end up in one of those states, and need help. But do you have any last minute things to say on the best interest before we pop off here? And also, I want you
Yeah.
to share all your socials with us, and also share kind of a time frame for when you feel like this is going to be finished, and if there's somewhere where they can sign up, a list or something to be able to get it.
Our social, YouTube, Instagram, Facebook, it's dad equal custody, and we have an email, dadequalcustody@gmail.com. And for people who want to get notified when the guide comes out, can send an email to helplawus@gmail.com, and that's HELPLAW@gmail.com, and they can put in the subject line guide, and then we'll make sure and let them know when the guide comes out. And the thing is, the guides are being designed for each state, but it's not hard to apply them in every state. It just takes a little tweaking, a little Google work,
Yeah.
honestly, and they can be modified for a state that's other than the ones that the guides are made for.
I was going to say, because I feel like, there might be, as far as like specific laws go, there might be things that are different from state to state, but a lot of what I've seen so far can really be just great advice no matter where you are.
Yeah.
So I would
Yeah.
recommend anyone that's going through custody, or knows that you're going to be going through one coming soon, that you guys email and get a hold of this guide, get a hold of Drew and his team, and get some help. These are some really good resources that are out there. I know I talk a lot about, we're spreading awareness, and I do what I can on our podcast just to spread awareness. But these are some great resources for people to actually get their hands on and be tangible, to help them in their effort. So I really appreciate that, Drew.
We also, and this is the thing that's more competitive because our time is a valuable resource, but we do take individual cases from different states. We've had
Okay.
cases in Maine, Illinois, California, Florida, Louisiana, Texas, Oklahoma, New Mexico, Colorado, and it's just those are the only people we've come across. But any state we can handle, because the system is pretty much the same wherever you go. You just have to know the little nuances. But the legal system is a process that operates in the same way. It's a standardized process in the United States legal system. So it wouldn't be like something in Russia or something. But even
Yeah.
then, their legal system mimics that of the Romans and the Greeks, you
Right.
know. So if anybody does need like specialized service, they can email to dadequalcustody@gmail.com and put in
Perfect.
there, I need help. Just the phrase, I need help. And if the resources open up, then we can help those people too.
And you might be able to help them as well fight. And so when you say take on clients from other states, are you talking about taking them on in the appeal process or helping them go after the judges or the attorneys that wrongfully what do you guys specialize in as far as what
All
you're
of it.
helping with? All of it.
All of
Okay.
it. Yeah.
Awesome.
Like we will go if there's already been a trial and the trial just happened, we might be able to like do some stuff to get a new trial before, because there's usually about 30 to 20 days after a judge makes a decision that you can
Mhm.
ask them for a new trial and preserve the record for appeal. But if that time is gone, we got to go all the way back to the beginning. We got to start a new trial and then
Yeah.
probably go through the appeal. But all the other stuff, the attorney discipline, judicial discipline, the Quitam lawsuit, the fraud against the United States, those are like separate things that we do as well.
Awesome. There might be
Yeah.
some people that I need to send your way. I think before we started recording, I was telling you about a guy that's being wrongfully imprisoned here in Tennessee, and there's a lot of us that we're signing petitions for him right now and trying to get
Yeah.
our governor in Tennessee to look at his case because she was an attorney and his ex-wife was an attorney in the county
Oh.
where they held court, and it was allowed to be held in the same courthouse that she practices in. Evidence was thrown out. The judge
Oh.
favored, and he's now serving 10 years in prison because of it. And so, yeah, there's a lot of people that could use y'all's help. So that's incredible. I'm glad there's people like you guys out there that do that. So,
Yeah, me
well,
too.
Drew, I'm so appreciative of you for coming on the show. I hate that I didn't get to see your face, but I love the slides. Those are awesome. And again, guys, if y'all want to reach out to him, it's on equal
Oh, you want me to
equal
say it?
sorry, say it again. Because I know on
Okay.
Instagram it has underscores, like dashes, right? Dad
Oh,
underscore equal underscore custody law firm. Is that it?
well, if you just put dad equal custody in Google, like you'll end up finding something. You'll find our
Okay.
Facebook page that has our web page on there. It has our Instagram stuff. So dad equal custody. But if people want to like get help or get no like to actually get help right now, they can go to
.com.
dadequalcustody@gmail.com. And if they want to get notified about the guide when it comes out, they can go to helplawus@gmail.com and put in guide, and then we'll send
Guide.
them an email and stuff like that.
Perfect. All right. Well, I really appreciate you, Drew. It's so nice to talk to you and hear your voice. I know we've been texting and
Right.
messaging back and forth, so it's great to get to hear your voice. And thank you so much for coming on the show. This has been a huge asset for resources. And that's what these families need more than anything is help and support and resources. So I thank you for being
Yeah.
on. To all the listeners, thanks for being here. Make sure you subscribe and follow. Go to our Instagram is and TikTok is Father's Advocate Mom, but our YouTube and Facebook is Deadbeat Dad by Design. And you can listen to this show on YouTube, Apple, or Spotify. Make sure you
share and follow and subscribe and help get the word out and send anyone our way that might need some resources. So hope everybody has a wonderful week. Drew, it was so good to talk to you, and
All right.